we're getting to fill some gaps in now, but obviously other people have got these gaps filled in, but they might not have every single scrap of information. I continually find new sources of information that I didn't know. Not a lot of people know that. Well, I do now. But even, every time I find a website that's about the history of petitioning, and I'm like, oh, look, there's some researchers, people know this stuff, or there's some more information, but it's like they don't have the information that I've just learned previously from another source. It's almost like some kind of patchwork quilt where, source one, they tell you about petitioning, but they've got certain informations in there, but not other informations. And then I go somewhere else, maybe a month or two later or whatever, and they have got different information and they know different things, but not the previous information that I just read from the other source. It's almost like certain people have, bits of different informations. And then you've got Parliament who compile memorandums or informations and frame and present it how they would like people to interpret and understand it, how would much best suited Parliament. So then you've got to read through their interpretation of it, and then you've got to challenge them on what actual legislative or statute or standing orders that it's based on. These here, we've got these resolutions. These are resolutions, and this is 1669. So this is some more knowledge now that has come to my attention, and I might not have, I could have not chosen to do any further research because I kind of keep feeling like I know enough already now. Well, I know more than enough, but it all seems to go back to the same things that you understand when you start off. So this is a resolution from the House of Commons, 1669. So this is after the Civil War and after Parliament gets established to be frequent. But it's a long time after John Pym and the Long Parliament when they were still receiving petitions for freeing people and then put through the House of Commons. And then, so this is like 1661, 2, 3, 4, 5, 6, 7, 8, 9. So this is like, 61, 2, 3, 4, 6, 7, 8, 9, 5, 6, 7. This is 7 years after the Tumultuous Act. So when you read this, and this is before the actual right to petition. Oh no. 1688, 69, 70. So this is before you actually get the right to petition or need it. But people have got the right to do it anyway because it exists. So much that they've even got a special procedure set out for it. So, when you read this, right, and you interpret this, you've got to take into account the 1661 Act and the procedures that have been prescribed in there for submitting petitions. But the thing is, also, you've got local council petitions and petitions to central government anyway, because obviously you've got local authorities still, which aren't going to be going to Parliament because it's in the local area. And that's something that you got to take into account when you're reading the 1661 Act. But still, so if there's only, you see, the problem is at the moment with all these Stop ULEZ campaigns and then all these, Free Palestine, Julian Assange, all these huge swathes of people who are gathering and engaging in these demonstrations, protests and petitions, is that there's a lot of people and Parliament are getting, it's a problem, particularly if you're talking about immunities and rights. Now, the thing is, if you think about it, the 1661 Act solves all those problems because you don't have them in the first place, because you don't have swathes of people who are officially engaged in any petitioning case that's submitted to the House of Commons, because if it's over 21 people, they've got to put it before justices or this larger part of a grand jury or whatever in order to get it looked at, to get it checked over and everything, so they know what they're doing. So therefore, you wouldn't have massive amounts of people until then when you get loads of people, then you get it looked at, and then they take account of it. And obviously then we need to find out a little bit more about that process, that what was going on. If it's under that many people, then there's not a problem, because there's only a few people. If there's less than 20 people, then it's not got to be a public concern, is it? Now, if those people are engaging in, obviously there's some sort of case to be had with Parliament, which you need evidence or facts or statements or whatever you need to do. Might be over a criminal matter. So, you might do policing work or investigative work or whatever. It's less of a problem when you've only got 20 people. So you can submit it straight to Parliament without it having to be, just hold on a minute, what's going on here sort of thing. But obviously now you've got all these Stop ULEZ people all over, like, 100,000 people or however many, all doing actions. But in a way, they are really... At least you've got groups now, people are officially documenting and recording and writing down what they're doing anyway. So it really, in a way, it's the government's fault for... You see, the government, it's the other way around. They're wanting you to get as many people... So they've put themselves in a pickle, really, because they're saying, like, look, we're not going to look at your case and do anything unless you've got, 100,000 people, right? So you've got to try and get as many people as you can, insane numbers, which is havoc for the police and etc. That's actually the fault of the government, because they're demanding that if you bring a case to government, you've got to have 100,000 people or they're not interested in it, basically. So it's actually Parliament's fault. Because if they'd say, like, if you've got 20 people and you can actually, submit proper casework and evidence, and it can be looked at on the merits of the facts and evidence without requiring 100,000 people, then they wouldn't have all these problems of all these protesting and chaos. So really, it's Parliament's fault, because they're not treating it like in the Inquiries Act, where it can be looked at based on strength of evidence or strength in numbers of public concern, because they're heavily restricting even the wording on it. And when you put links, then they start to say, we don't want to publish these links. Why? Because it's evidence. There's also some other information that I've read, which actually there were quite a few things that are officially published by Parliament in a few documents that I've just read that I know they're not doing at the moment. They're not complying with that. But there's some other internal procedures and rules as well that the committee didn't tell me about, but I don't think they affect us. They just affect how it's dealt with within Parliament. But anyway, so we'll read this resolution, because I think this is the one that they're using for the excuse to reject them if they fancy rejecting them and not letting them in or not running them. But they can't really reject them when you write them in paper, because you hand it in, don't you? I mean, if you collect all your signatures, 100,000 signatures in a box printed out, and you hand it to your MP, that's it, you're done. But they don't even know you're doing it until you turn up with it and then you hand it in. You could have evidence attached to it in statements or whatever. They might not know anything of it till you hand it in. So, I mean, then all your investigation work's done. I mean, but the thing is with online, you're kind of like, it's almost like, submitting an appeal to a Crown Court from magistrates, once you like send it, then that's it. I mean, the magistrate, if you send an appeal to a Crown Court, a case it doesn't really matter whether it's an appeal or a new case, but in the instance of an appeal, all the magistrates' court matters are annulled because you're appealing to a higher court. And as soon as you submit it and they receive it, then, you get a day and then you can do what you want while you're waiting, a month or 2 months for the hearing. You can, submit documents, give directions and do investigations. And, if you really know what you're doing, you can actually have, mention hearings and so forth if you wanted to, whatever, get warrants or anything, add more evidence as long as it's before a certain date or whatever. You can do things, basically, you can act in connection with that case. And also, when you have your first hearing, I suppose, depending on how long the case goes on for, you can continue it. I mean, I don't know about in the Crown Court because you have a jury, but I don't know like if they have to make the jury keep coming back again. But obviously, oh no, because that's sentencing, isn't it? Sorry, they have a jury when it's sentencing. I don't know whether they have to do it on the same day or not. When the Crown Court. I haven't actually been to a Crown Court before and had a case myself there, but anyway, get back to this again. So, they're saying that it is an inherent right of every commoner in England to prepare and present petitions to the House of Commons in case of grievances, and the House of Commons to receive the same. So why would they need to put this resolution here in 1669? This is before the right to petition, but it's after Long Parliament and John Pym and the Civil War. So it's an inherent right of every commoner in England to prepare and present petitions to the House of Commons in cases of grievances, and the House of Commons to receive them. Well, why would they put that? Well, some people might not have been. They might have been stopping people from doing it, or people might not have been able to, and they might not have been receiving them. And to me, that clearly is something to do with that process in the 1661, that, if it's over so many amounts of people, it says it is the inherent right of every commoner in England to prepare and present. So, if they've got like 20 people, under 21 or 20, whatever, 20 people, they likely wouldn't have had any problems because it didn't have to go through those other courts. But if it was over that many, they had to. There was this other process before, although there's some question of whether it between going to the local council or to Parliament. But in terms of the House of Commons, now if it's over a certain amount of people, like let's say you've got 50 people, and it's one petition over one matter, I'm guessing that why would they go out of their way here to say that it is the inherent right of every commoner in England to prepare and present them? Well, if there's a group of like 50 people and it's the same matter that they're petitioning about, and one of them prepared it, but they all wanted to come and present it, they might have been trying to exclude people from turning up and say, look, there's too many people here, 50, like, only two of you can bring it in to get looked at. Basically, they didn't like they likely were. They probably were having arguments over, everyone turning up. We have the similar problem at the moment. I can compare this to a current issue. Local council authorities in planning applications, when there's a very, very large number of people in a village and they're all objecting against a planning application that's council trying to put through with their corporate buddies, and everyone from the village decides they're going to turn up to make sure they hear what's happening and find out what's going on. They want to be there in person and have a say and speak, and they turn up and they can't all fit in the room, because the council have got various different rooms and premises, but they book, they reserve a slot in an extremely tiny closet room, like the TARDIS, and no one can fit in. Like 8 people can fit in, but there's 50, so everyone's complaining that they can't hear what's going on in the room, or they can't see and they don't know what's going on, and they don't have enough room to speak and so forth. That is a example. So that would be that you could read this for an example, that it is an inherent right that every commonwealth in England to prepare and present objections to planning applications in the local council. Now, if they can't fit in the room because the council have booked a small room at Kirklees Council, crafty buggers, then everyone hasn't really got a right to present their case because they can't fit in the room, can they? So that would be a good example of why you might need something like this if you wanted to make sure that every single person who was going to turn up did have a right to present an objection and be heard, and also prepare them as well, separately. That would be an example of why I would have thought you might need this. If they were saying, what happens if there were 500 people? Why would you need a resolution? The House of Commons needs a resolution about this process. When is this? Well, it's in 1669, so it's not that long. It's a couple of years, a few years after Tumultuous Petitioning Act. So they're looking for a resolution because they're having disputes and arguments about when there's a large number of people. Basically, some people they're probably not too impressed when there's I don't know what happens if there's an entire village or something that's signed up, and they're probably saying that what if they all write their own separate statements, and then theoretically, if it is over a similar or the same matter, and everyone prepares their own individual petition statement, then you got to amalgamate them together, haven't you? Because it's one case and they're all statements for it, and therefore that's why you amalgamate them together. And if there's 500, they might have been like, whoa, there's two, they might have been able to say, look, one of you can write the petition and you all just, put X on it and sign it. And they're like, no, whoa, no, we can all we've got a right to, each one of us has got a right to do it. So that would probably, I would have thought that seems logical to why that number 1 would have been necessary. And then number 2 is that it is an undoubted, so this means you can't even doubt it. You're not allowed to even have any doubt at all, which means that you have full confidence. It is an undoubted right and privilege of the Commons to judge and determine concerning the nature and matter of such petitions and how far they are fit or unfit to be received. Well, this is the problem. So there might have been these other justices, magistrates, and or larger part of a grand jury who were meant to be looking at these petitions might have been kind of taking it upon themselves to judge them themselves and not pass them on to Parliament. Think that they're fit to make judgment of them. If the petitioners are petitioning Parliament, and they might not have reached Parliament unless we are absolutely clarified without any doubt and confident that it is the right of Parliament to receive them. Parliament have a right to receive them from, the justices of, whoever has been checking them over and looking at them. If it's over, there's 21 people or whatever, they might not be making their way to Parliament, or they might have not, if they are fit or unfit to be received. So no, Parliament will decide that. How far they are fit or unfit to be received. So, you see, what the House of Commons in the modern day will like to entertain this as the interpretation of, it's all about them. We'll decide whether or not these petitions can be heard or looked at or not. Well, you're looking at it when you've got it in your hand, aren't you? But the thing is, if it's going through some other body, some other justices or grand jury or whatever, they might not get into your hand. How far they are fit or unfit to be received. Well, if they're not being